I would like to ask our panelists and the moderator of the panel, Katalin Szajbély from the Hungarian Helsinki committee, to come forward to the table. The participants of the panel discussion will be Tamás Dombos, project coordinator of Háttér Society, Louisa Klingvall, András, László, Pop, research professor at the HUN-REN, I don't know how to pronounce it in English, Center for Social Sciences Institute for Legal Studies, and also professor at the Eötvös University Faculty of Economics, and Erzsébet, Szalayné, Sándor, Deputy Commissioner for Fundamental Rights, Ombudsman for the Rights of National Minorities in Hungary.
Yes, so hello and welcome everybody back after lunch, and hello Louisa, and thank you for your very exciting and very challenging keynote speech. And now I would like to give the floor to all the panelists who are all very long time and renowned experts of this topic, of the topic of hate speech online and offline from different perspectives, to share their thoughts a little bit about European legislation and the challenges it poses to all of us about hate speech. My first question, or the first issue I would like to raise with you, is what you believe that in today's very difficult situation and all these complex issues we are dealing with, which kind of legislation is more effective? Are hard law or soft law instruments the more effective in combating hate speech, online and offline hate speech? And how do you consider the current framework of legislation? Do you think it is an optimal mix of hard law and soft law instruments, or would you rather change it up, mix it up a little bit? So who would like to begin? I wouldn't like to impose any. Okay, András, please.
Okay, thank you, and thank you very much for having me here. We received 2 questions that we will probably be exposed to, and I was hoping not to need to comment on the first one. I have some thoughts on the second one, if that actually gets raised. I'm not a very, usually I'm not, my focus is not a technical one. I'm not actually a practicing lawyer. I don't even have a bar exam, unlike you guys. But surprisingly, my answer will be a technical one. So when it comes to law, as a social scientist, which I consider myself, I always begin my assessment saying that law is simply the end of political discussions, and this really, and not all the discussions will end up in legislation, but most of them will. Even if we're talking about policy solutions, at the end of the day, it will be, I don't know, tax laws and So in this regard, I'm not really concerned about whether it's soft law or hard law, as long as it's law. The really question is, what do we want to do about hate speech? And it's going to be a political question. We're talking about this week, the AfD has 25% support in Germany. In some Länder, it's 30. It's an entirely political question whether some forms of speech are facing criminal or legal sanctions at all. What I want to point out, and this is where my technical response comes, is there are 4 main ways how law can sanction speech, and it's also not entirely clear which is what is clear is the strongest legal response to speech, to sanctioning speech, is criminal law. You say something and you go to jail or get fined or something. What's not in that's one option. The other option is civil law. That is, if you, and for example, this is what the recent Hungarian legislation goes for, that it's also a civil sanction. It's a violation of dignity and you can sue someone. We don't really have an extended jurisprudence in this. We don't know what the courts are saying. Some actually can say that this may even have a more chilling effect than criminal law, because if you're actually sanctioning companies or the media or people expressing their speech and you get fined for that, you don't go to jail, but you get civil fines, that can actually chill and freeze speech even at a more severe level than criminal law would go. So that's another way. Another way to go is, and this is what I'm most intrigued by, is administrative law, in particular anti-discrimination legislation. So one of the recent, and I can go on and talk about this because this is really inspiring, is how, for example, the concept of harassment can be joined with the concept of mostly in the context of political or speech by politicians, that is to create a humiliating environment that amounts to discrimination, and whether we can deal with that. And actually administrative law, anti-discrimination law is, I think, the most or the least dangerous way to approach this question. This is, I think, this has the least effect on how, on chilling speech. And of course, I agree with the previous speaker that this is it is an unhealthy simplification to say that, well, we have speech on the one hand and then we have hate speech on the other hand, and every sort of hate speech legislation is an inherent and unacceptable and highly problematic limitation of free speech. But technically speaking, it is. These are the discussions we have, and I will stop here in a moment, with our colleagues when we're talking about hate crimes, that, well, there are hate crimes that are actually physical violence of some sort, and then hate speech is a very different type of harm that is being caused. Technically, or I guess politically speaking, and also legally speaking, as a constitutional lawyer, it's very, when you have this sort of the balancing procedure of having, considerations for one right on the one hand and another right on the other hand, when it comes to classic, the narrowly defined hate crimes, we don't really have a problem there, because no one has a right to beat someone up, right? You don't have to balance anything like that. Speech is an essential, human quality. This is how we do all sorts of things. This is how politics works. This is how, confessing love, it's very important. It's very essential for humans to engage in communication. So I think these are the, I guess, junctures of what I see as avoiding answering your question.
You go first.
Yeah, I think thank you very much for the invitation. My name is Tamás Dombos and I work for Háttér Society, which is the oldest and largest LGBTQI organization. My specificity, besides working specifically on LGBTQI issues, is that I'm not a lawyer, unlike all the other people on this panel, or four people on this panel. But I've been working in our legal aid service, monitoring hate speech online, contributing to the code of conduct monitoring, as well as launching legal cases against hate speech in various forms, in various legal fora, all of the ones that András have mentioned. So that's the experience from which I'm talking to. And I think when it comes to the question of soft or hard, I think we should start from what exactly victims of hate speech expect from a system, or what we can expect from a system. And I think there are three things that are crucial, and unfortunately those three are very difficult to combine. And the three things is speed. We want the harmful speech to disappear as fast as possible. Because if we need to wait 2, 3, 4 years for a criminal procedure to have a legally binding outcome at the end, by that time the harm has been done, the impact has been done. So it has to be speedy. But on the other hand, we also want some kind of transparency, that we understand what are the reasons why a content was removed or sanctioned, why a person. And we also want people to be guarantees in the system that removal or sanctioning is not done in an arbitrary way. So there needs to be some kind of appeals procedure. And unfortunately, those are very difficult to combine, because if you want a speedy, you can't have like multiple layers of a procedure. If you want transparency, that also needs a lot of efforts to make that procedure transparent. So I think the only way to go about it is to have multiple fora and multiple ways of handling hate speech. And I think that's where the system is going to. So we do have the code of conduct, which offers a very speedy procedure. I'm not sure it offers the level of transparency that we would expect from the system. Maybe the reporter gets back some kind of feedback if they get back, but the public doesn't know what happened. The public doesn't know what kind of content was removed, what was deemed unsuitable for Facebook or Twitter. We don't even know aggregate information about how much content was removed and for what reason. So there is a complete lack of transparency in the implementation of the Code of Conduct. And regarding the appeals, well, some of the platforms set up some kind of appeals procedures, but they're very new, so it's very difficult to say anything about what's happening there. When it comes to the hard law aspect on the European level, well, we have the framework decision, but it's a framework decision. It's not even a directive, let alone a coherent system that is the same. The definitions are not there very clearly. And unfortunately, what we see, and I think this is the political problem of hate speech, even if there is legislation which is clear, it's just simply not implemented, as it is in the case of Hungary. We have criminal law sanctions against hate speech, which is simply not used. And the reasons for that is very complicated. There have been several efforts to update it, but it seems like there are certain institutional barriers for the proper implementation, and I think some of the other questions that are coming up will help us answer why exactly that's the case.
Thank you. Thank you also for the invitation. And well, my perspective is somehow different from that what we have heard until now, because I am, from my normal profession, I'm a professor for international public law and European law. In the last few years, I had the possibility to as an ombudsperson, to go beyond the law and to experience what does it mean if public officials, authorities do not really understand the social circumstances of certain persons and groups. And this is which leads me to the impression that there is no real or there is no one-size-fits-all model of how to combat hate speech and what should be the balance between hard law and soft law regulations, or hard law and soft law, or soft law tools, or only soft tools. Because yes, law is law, even if it is soft law. But as we well know, when we look from up, down, going up, we have a perspective from up going to down. Then in international law, as high you go and as general and as universal the treaty is, or a legally binding document is, it is more and more abstract. So you come at the end to principles. And it is at the end of the day the obligation of the states to make and to pass really hard law instruments, as it was said by András a few minutes ago. This is why, in my logic, and I was I had also concrete experiences as a member of the advisory committee of the Framework Convention on National Minorities, which has also the Article 6 and paragraph 2 of the Article 6, which gives the possibility to advisory committee passing only opinions, which is what? Well, max it is soft law about the state of affairs in different countries of members to the Framework Convention on National Minorities. And I have to say that, but the Article 6, paragraph 2 of the Framework Convention is closely connected to Article 14 to the advisory to the European Convention on Human Rights. And at the beginning of the 90s, when the Framework Convention was drafted, it is perhaps not well known, that part of the events, but when it was drafted, then it was clear that Article 6, paragraph 2 is only connected to national minorities, national ethnic minorities. But there is a need in the framework of the Council of Europe to have a general possibility and general body which mandate is to monitor in general the situation and I mean racism and in the member states of the Council of Europe, and of course also hate speech. So this is why if you look, for example, to the opinions which were given by the advisory committee in the last few years, then to the 36 member states, then you will see also in the Hungarian opinion, which was made public in 2020, one and a half year ago. Or you can see some standards, some trends about hate speech, and you can, for example, come to the conclusion that the main target, the main group of persons which are somehow subject of hate speech, either as perpetrators or as victims, are the young generation, Z and I and Y. Y, yes, is the newest one, the freshman. Okay, so what I wanted to say, and yes, you and the channel for their communication is the online sphere, the different online platforms, meaning you cannot reach them, you cannot change their attitudes to hard law. And that is too far away from them. So you have to start with soft law or soft tools, and this leads us to the need of education, which was many times mentioned today, I think. And if, well, I was thinking a bit about. I don't know if it is correct. Please forgive me if the comparison will be a bit too hard. But if you would think about the needs, how to combat hate crime, what kind of tools you should use, hard law tools or soft law or the mix of this, then you have to imagine a kind of Maslow pyramid. And the lowest level, which the size of the lowest level depends on very many things. I mean, age of the population or the group which is a target, or the profession, or many other characteristics. And then on top of that, you can come with, well, on the lowest level, you have soft tools, education, teaching materials, building local communities, and so on, involving the youth. And then go further with soft law tools, and then with national laws, and then international, and so on. So I think I don't know if this comparison is somehow not taken from too far away, but well, I can imagine. Well, this is my answer to your question, is that. I don't think that without a significant, I mean, for me, soft law tools are number one. And without soft law tools, depending, and again, stressing that there is no one-size-fits-all model, I don't think. And the hard law can come afterwards. Without soft law tools, you do not reach anything with hard law.
Thank you very much. And Louisa, please share your thoughts.
Thank you very much. I mean, I think I would have to agree very much with previous speakers. I mean, the law, I mean, the easiest thing we can do is to legislate. It's pretty simple. I mean, it takes a few months. We have to negotiate with the co-legislator, and then we have a law. But we cannot kind of wash our hands there, so to speak. First of all, to the extent that we have put the legal framework in place, we really need to do the hard work of ensuring the correct implementation. And with that, I'm not only talking about ensuring that the member states implement it and transpose the legislation correctly, but also that it is enforced. And I mean, there we have a number of obstacles. I mean, it could be lack of willingness, lack of resources in the area of hate speech, I think a very large problem is the fact that these are not considered as the most serious type of crimes, but at the same time, they're incredibly expensive to investigate. Normally, you don't know who the offender is or where this person is, and it requires a lot of resources and efforts to investigate. So I think improving, for instance, capacities with law enforcement in terms of cyber investigation skills, ensuring that there's access to all the necessary open source tools to help investigate these crimes is incredibly important. But of course, the criminal law side is only a very small part of it. And within the criminal law, we have to work with both soft law and hard law and capacity building in particular. Outside the field of criminal law, clearly, as was already mentioned, education is incredibly important. But I also think since the online world is very much the vector for this, we need to go beyond traditional education. We need to look at successful counter speech methodologies. And we've seen in the past a lot of, we have campaigns where we say no to hate, but I think it's chiefly watched by those of us that are already convinced by this narrative. So having more understanding of the radicalization process of the persons that spread this content and how to help de-radicalize through a dialogue, I think will be very, very important moving forward. So overall, I think that what we need is a really good policy mix of different instruments. Thank you.
Thank you very much. Thank you for all your answers. And I think we can say that you all agree on the fact that a very wide range of measures is needed. So you told lots of measures that are indispensable to be effective against hate speech. You spoke about education, about quick and transparent procedures that are needed to step up, about the concept of harassment that can be used against hate speech, about the need of very effective enforcement, about successful counter-speech strategies. I think these are all very, very interesting and very useful tools. And now my second question would be, or the set of second questions, how do you consider the use of all these tools? Is it effective? The current use of all these tools? Is it effective from the perspective of the victims of hate crimes? And do you consider all these tools and the other tools effective, considering all the marginalized groups you represent, or the other marginalized groups that have been represented or have not been represented today, and also the society as a whole, as a functioning democratic society? So are these tools now effective from all these perspectives? I hope my question was clear.
It's the same order. Thank you. That's a very good question, and I've been thinking about it. But before thinking about the answers, I was actually stuck with the question itself, and I think it really relates to a lot of things that have been mentioned earlier. Is that my question is who are the victims really? I mean, I think this is a very important question of definition, but again, it's a highly political, not a legal, but it's a very, very political question. So and I think there's a stark difference when we're talking about the offline and the online world. One can just say that as as long as, you know, you can always just leave Facebook. I mean, if you're really troubled, but you don't, I mean, there may, you know, there's an argument saying that there is a very important difference between the classic pre-internet hate speech, where there's this clear and present danger, incitement to violence, and then there's a captured audience. And so people are directly exposed to the consequences of harmful speech. And, you know, if this whole, you know, the pyramid of hate from speech to, you know, bias, and then actions based on bias and leading to violence and even genocide at the end. So there's a straightforward, you know, potential, a direct potential in a straightforward progress from one to another. That's one thing. The other thing is that, well, you know, you can always just log off. Where do we actually draw the, I mean, are these concepts that we've traditionally been thinking in terms of hate speech, again, clear and present danger, captured audience, how do we adjust this when we talk about the hybrid life that we live in, the online and the offline world? So that was one of my questions. And I think, you know, I don't have an answer to this, but I would need that in order to answer your question. And also the other thing is that, which again, I am no enemy but of identity politics. In fact, I'm a student of these processes, and I'm fascinated by all that goes. But that actually, again, touches on the core and essence of who are the victims. What are we talking about? Agents? Are we talking about people who claim to be speaking on behalf of communities? And the question comes in that, you know, how loud their voices can be heard, and how is our perception and definition of victims framed, and how you know, who are the actual victims? We have seen the traditional list of protected characteristics in anti-discrimination law and hate crime legislation. We have, you know, a standard 5 to 7 or 10 definitions, and then we have more and more. We have a proliferation of groups coming in and say, okay, we also want to be protected. And again, who gets to say that, okay, well, that has been enough, that has been, because traditionally the very, again, of course, I'm simplifying arguments here, but traditionally the argument when it came to hate speech was that, well, generally speech should not ever be restricted because that's so important for us, but we can have legitimate exceptions. Okay, we can say that the Holocaust deniers, you can't do that. This is just really, you don't get to say that. You can say whatever you want, but that is off limits. And then maybe we can extend the list of exceptions. But the question is this theoretically sustainable? Is this, you know, does this traditional model for how do we, you know, where do we draw the general line of speech that can be restricted? So these are my, you know, the questions that I'm fascinated by you know, by following the you know, the social and political and whatever developments in the world. And again, I come back to where I started. So this is a political question. As a constitutional lawyer, I don't really have a problem leaving it to the very complex dynamics and interactions of all sorts of actors in politics. Of course, there are limits. We have clear limits that you know, international, you know, human rights bodies have pretty much in sync, have developed, okay, that there are some limits, but within that we have a very wide range of appreciation that, you know, policies can go forth, and various agents, various actors can sort of, you know, engage in a dynamic relationship. So for example, in Hungary, we don't usually use Hungary as a good example, but in this case, I think we can say in the past, in the first 2 or 3 decades after the political transition in Hungary, there has been a table tennis between the Constitutional Court and various, you know, legislative attempts to criminalize hate speech. So there was a law, and the Constitutional Court said, no, this is not good, and it went on, and then at the end of the day, the new constitution adopted in 2011, which again we can say, talk a lot about that, but in a sense, I think it's okay. The people said that, okay, with the constitution, we're resolving this issue. This is the will of the people. Let's not get into, you know, the broader context of that. And you know, the term that is used over constitution, I think that's a part of a normal process, saying, okay, now the constitution will end this table tennis, you know, interaction between the Constitutional Court and Parliament. We say that hate speech is allowed. Criminalizing hate speech is allowed. You know, human dignity is beyond, you know, can prevail over speech in certain points, and that's it. This is how we want to end this discussion. And you know, from my point of view, this kind of, you know, makes sense. I don't particularly have a problem with that as a constitutional lawyer. Again, not having answered your question.
But you knew that. Yeah, there's a lot to react to, and there was a lot to react to in the question as well. I think the question of who's the victim is crucial, and I think it's related to the practical difficulties of having proper implementation and transposition. Because the kind of hate speech that targets particular individuals is quite easy to handle, and I don't think that's super problematic. There are civil law sanctions that work. You simply sue the person that said nasty things about you, and you will be awarded some kind of compensation for what happened to you. If it's a criminal law, you as a victim go, you report a crime, and it will be investigated. If you don't like what the reasoning of the things that the police did, you can have, as a victim or as a concerned party, in the procedure, submit a complaint that will then be decided by someone else, etc. The difficulty comes when the hate speech is not targeting individuals, but whole groups, when it's the whole Jewish community, the whole LGBTQ community, because there, neither in civil nor in criminal law, there is no victim. And that's the difficulty. In the civil law, it's clear who can start in the procedure. Now, the Hungarian law has a solution for that. It can be any NGOs representing minorities, of course, the selected minorities that are mentioned in the constitution and in the civil law, civil code, and that we have to be very clear. LGBTQI people are not protected in that way, and the civil law sanctions are not there in place because LGBTQI people are not mentioned in the closed list of groups that can have that civil law solution. And in the criminal law, well, you're not considered, and this is the practice of the Hungarian authorities, police and prosecution, and unfortunately courts as well, there is no one to take the place of a non-individual, of a group. There used to be solutions in our criminal procedure law that in that case, when there is no clear victim, an NGO can come in. That's no longer there. There is no entity that can somehow enforce and complain and then push the cases forward. And that's why the criminal law sanctions are not used in Hungary, because it's not used by the police, it's not used by the prosecution, but there is no one who can challenge those decisions in court. And there are plenty of cases where the courts are saying it would be really great to finally have cases in front of us that we can decide so that we can upgrade our earlier jurisprudence in line with the new constitution that was adopted. But there are no cases on which the court can come in and say, this is the new standard based on the constitution, because it's just unlitigatable. So that's a very specific problem that we have, and I think it's a problem in many countries that in the criminal law sanction world, it's very difficult to attack that kind of hate speech if there is no legal entity that is not the state, but someone else who has an independent position in the procedure. So I think that's the difficulty with the why the implementation is problematic and why there is no easy solution for that. But there was another part of the question that I wanted to respond to, and it is the procedure or the legislation, victim-centered? Are the needs of the victim met? And I think we need to understand what are the needs of the victim. And of course, there are many aspects to it. It might be around safety, because if someone gets personally targeting threatful messages, it's a question of safety, personal safety, and surviving. That's a very specific need that needs to be responded. I don't think in most of the countries, if someone receives those threats, there will be any kind of police intervention that, or even advice given to the person what to do or what not to do. And if it's done, it's probably done in a way that is only undermining the human dignity of the person, saying things like, well, don't be so public about your sexual orientation, about your religion, or something like that. That's most likely the guidance that you would get from police. And then the other aspect is some kind of sense of justice or a response to the fact that when there is hate speech, it's basically giving you the message that you don't belong, that you don't matter, you're a second-class citizen. And victims simply need a counter message saying, no, you do belong, you are not a second-class citizen, you are just a person of equal worth. And this message can come from a lot of actors. It could come from the criminal justice system or any kind of justice system, but it could come from friends, it could come from family, it could come from mates, from colleagues, from politicians. There are many bodies that could deliver this message, but of course the difficulty is we're talking about minority groups that don't have that support network very often, that could easily say that. If they are belonging to minority religious groups or minority ethnic groups, you know, who will be their colleagues or who will be their mates who just, you know, stand up for them? And who will be the politician that does that? And it would, in many cases, for a victim to not feel threatened and not feel the impact of that rejection that's coming from hate speech, it would just take a few words of saying, you should not take this seriously, or take it seriously, but this is not the whole community. This is not the majority. This is a few individuals or a small minority of the society. But unfortunately, in the current Hungarian context, you get exactly the opposite. The government would not, or the politicians or public figures would not deliver that message, but even a message that fosters hate against these groups.
Thank you. I do not have the real answer to the question, but I would put few more questions. The one question was, if I understood well, that how effective are the victims' rights now, or how was it somehow part of the question?
How effective is the legislation from the perspective of victims?
So, first of all, I think that, and of course, it's clear that it's hard to define who is a victim, and it is also very hard to understand or to find someone who is speaking for a group or a community of persons. But for me, one more question is, and I think that the victims' rights, we can't speak about the effectiveness if we are sure that the person who is a victim has internalized the fact that there is regulation, there is a law which tries to help, which tries to give some compensation, which tries to protect the person, to give to the person a possibility to go to court. And without that, it is very hard for a person who possibly is a victim to behave as a victim. This is one point. The other point or question, if as you like, is which I would like to raise is the police officer, the policeman is might be in a situation also a victim, and in another situation he is a policeman representing an authority, and he has to follow the rules which are there for the protection of the victim. So the question is, if the policeman is clearly following the rules, not doing anything else but following the rules, not going beyond that, not having emotions towards the person who is a victim, well, I would say that he has done what he has had to do as a police officer. But I think that we should not stop here, and it is not enough. That's the 0 point. You have to somehow go further. Also, in the case of a police officer, he has to accept that, for example, the regulation which is in favor of the victims is something which is needed in a democratic society. And this you can only achieve with hard law tools. You cannot go beyond that point, beyond that 0 point. And this leads us to the, what's the English name for that? Organizational culture or whatever. I mean, somehow, yeah. So, and well, these are only, again, question marks and points we have to raise when it comes to the effectiveness of the legal regulation about the victims' rights.
Thank you very much, and please, Louisa, share your views on my questions, and maybe, if you would like, also on the other questions that have been raised by the panelists. Thank you.
Thank you very much. I mean, in a way, I think this is an excellent example of I mean, the difference between the law and its effectiveness, because in terms of the laws at the EU level in respect of at least racist and xenophobic hate speech, I think the laws are there. I mean, the framework decision applies to both individuals and groups. It's not requiring that a complaint is based or that there is an individual person with locus standi. I mean, these are not personality crimes. These are crimes that should be pursued directly by the prosecutor. In terms of how the victim is being treated from the moment they arrive to the police station or report the crime, and in the follow-up, we have the Victims' Rights Directive, which provides a number of specific rights to vulnerable victims, including victims of hate crime offense. But are they effective, was the question. And I think that we have to admit that when we look at all studies that have been made, which asks the minority groups about whether they've been subject to hate speech and hate crime and whether they have reported it, we see that there is a very, very large problem of underreporting. And that underreporting stems from a lot of the issues that were raised today. It's the fear of not being heard, fear maybe of even being of double punishment, because you might even receive an attitude when you report that will victimize you once again. So yet again, it is a question of implementing this on the ground, not only looking at what does the letter of the law say in country X, Y, and Z, but how is it implemented and what are the resources put in place to implement. And I think here, I mean, as was mentioned, the organizational culture, training of law enforcement to meet with minorities in their needs are incredibly important. So, yeah, I think that would be my answer to the question.
Thank you very much, Louisa, and thank you for all your answers and for all your questions you raised. I think even more questions have been raised than the ones that have been answered, but this is good this way because it shows that there is still plenty of things to explore and to maybe rethink in all these very complex topics. And not only from the point of view of legal regulations, if I understood all your views correctly. And Louisa shared the concept of underreporting, which I think is a very, very important concept in this field and also in the field of hate crimes and discrimination in general. And this leads me to the third question, to the importance of the third topic, that can maybe some kind of strategic litigation be useful to multiply the effects of the existing regulations and legislations. And what came to my mind when I thought at first about these questions was a quite recent judgment of the European Court of Human Rights. It is Lenis versus Greece. It was, I don't know if you heard about it, Tamás surely has. It was Metropolitan of the Greek Orthodox Church. That means a very nice religious man, should he have been, who posted an article containing very, very severe homophobic hate speech, containing sentences like they are scum of the society and they should, you should spit on them, and so on. And the European Court of Human Rights declared that extreme homophobic speech is not at all protected by the freedom of expression. So he didn't seem necessary to even investigate whether it was proportional, whether he said it simply didn't fall under the limit of freedom of expression. So what do you think about strategic litigation as a tool?
Yeah, well, finally, I've been waiting. This was the question I was really waiting for. Let me just make clear. So when this is not an official definition, but at least I think there are two types of strategic litigation cases. Both are extremely relevant in the hate speech context. One is when sort of a class action type of litigation. So we have certain agents who are capable of speaking on behalf of the ones whose voice is otherwise not heard. So this is one thing. This is extremely important here because underreporting is usually caused by marginalization and even the unawareness of the fact that rights have been violated, and the whole idea of that justice here is symbolic justice to a large degree. So that part. So that's one thing. The other thing is strategic litigation in a more in the other sense when litigation is used as a tool for social change and also for legal change. So when there's no legislation or the legislation is inefficient. So the classic case is the American 19th century Plessy versus Ferguson, which wasn't very successful in the end. But so let's stage a case where someone who looks white but actually legally is not white would purchase a ticket, get on a train, and then casually mention that, well, actually, I'm actually not white but black. And then there's a detective who was also hired by the same human rights organization, arrests that person, and then they go to court. And then the idea was to make the Supreme Court say that segregation is unconstitutional. Again, the case was not a perfect victory, but anyway, that's it has served very important purposes. So this is the kind and sometimes even if there is legislation, the legislation is not implemented properly. The legislation is not. So I think this is a very, and it's also a very exciting area for human rights lawyers. I would like to mention one case from Hungary again, which again I always bring up because I love to mention this, and this is a strategic litigation project that has been initiated by the Hungarian Helsinki Committee, and this is something that. So at the time there was no hate speech. There was no. This is something that I mentioned earlier. At the time there was no hate speech legislation was not enforced. There were some attempts, and the Constitutional Court always said that's not working. So there were no legal measures to talk about. In this case, it was racist hate speech. And then so what the Hungarian Helsinki Committee has basically pulled out of the box, saying that okay, let's try to look at harassment as the legal category under the auspices of which we can tackle hate speech. And basically the idea was these were all mayors, so local, and because then that would have fit sort of the definition of the anti-discrimination legislation, that so members, local Roma, were arguably humiliated, intimidated by the speech of their local political leader, the mayor. So the question of how far can speech radiate to individuals when it talks about a general group of people. Here the argument was made, well, if this is a mayor of a small village, then the locals, maybe Roma living in Budapest could arguably not be really intimidated by a mayor saying something racist 250 kilometers away, but the local ones, I mean, this is the guy who's basically running the local government, then we can try that. And that was actually very interesting, table tennis, so various courts, and it has reached a number of places. Anyway, so that kind of a strategic litigation approach, I think, is even has promises for again using law to make both social change as well as actually change within the legal regimes and instruments.
Yeah, strategic litigation is one tool that many human rights organizations use. I think there are a few things that is problematic about it or might be difficult, even though this is an activity that my organization is very happy to and very intensively is engaged in. I think one difficulty is that for any kind of strategic litigation, you need to have trust in the judicial system that it will deliver meaningful results in line with international human rights norms or the constitution of the country. The Hungarian court system maybe at some levels is still trustable in that way, but the highest levels of the court, the Curia and the Constitutional Court in Hungary currently is not an independent body. They make political decisions based on perceived political interests. So even if you win all the way through, you'll probably very likely lose it at the very end. So in terms of the Hungarian solution to it, not very likely. Or you even win it up to the Constitutional Court, and then the law is overwritten, as we saw in the case that was mentioned, the Gyöngyöspata case, but also the legal rights of transgender people, many cases where legislation was changed after a successful court decision, or even the Constitution itself was amended to then put in provisions that are in line with the political vision of the government. So in that sense, having a strategic litigation in which you no longer can trust the judicial system to function in that way is very difficult. And unfortunately, when it comes to international fora, you might get good decisions, but then those decisions it takes super long. Again, the time element of the impact of the original problem is not taken into consideration. And then those decisions have to be transposed and implemented. There are plenty of European Court of Human Rights cases now in Hungary which are simply not implemented. What can you do if you cannot even have trust? Well, you might trust the institution itself, but its enforcement in Hungary you can't trust anymore. So strategic litigation is an interesting and important tool, but what the results can it deliver in a country which no longer has basic rule of law? It's a very big question. And the second question, I think, which is a very different type of question, is strategic litigation is a very elite activity. And I think it's very difficult to explain to the communities why that kind of approach of strategic litigation is needed. And it's very the distance between the victims and the clients and the judicial system, especially when using this strategic litigation, long-term litigation, is so big that it's very difficult to convince the communities themselves to trust strategic litigation, because it's so remote and so distinct from what they experience in their everyday reality, that there is this kind of disjuncture between the two. Yeah.
Now I am sorry that I am the third speaking after you, because that would have been my point to raise by saying, but I can only but echo what you have said, that I wouldn't use the word elite, but I would use the word professional community. I mean, the ones who really understand what is law about, how the legal system and how the judiciary is working in that certain country. I think that to achieve a change, and also a legal change or a societal change based on outcome of one or another strategic litigation, you need the wider public to be aware of the fact that there is strategic litigation. What does that mean? Because if I'm not mistaken, strategic litigation is not a European invention. So the effectiveness and everything else, I think, has to be measured on somehow else in the European context. And this means that you need to be aware of also of the fact, and this is I would say the duty, or at least the possibility of the ones who are the agents who are going and who are having this strategic litigation as a tool, how to bring near to the wider public the outcome, and what does that mean? Why is it important? Because if you rely on how should I say, the politically motivated media outlets, then you might go in the wrong direction. So this is the question: how the outcome of strategic litigation can be brought near to the general public, which I mean can be only indirectly affected by the concrete subject of that certain litigation. Yeah, and the other one is that the Hungarian courts are not binding. I mean, it's not a common law system. So, of course, they can, if they want, then they can not. I mean, they are not obliged to use the same interpretation, for example, in a case. And I was very... it's very interesting for me to read about the case you have mentioned, Kata, by the European Court of Human Rights, because it's, I mean, that's not a thing the court is using to do. I mean, without going and saying so strict. So I think that the actual composition of the court is somehow feeling and understanding that we are going in wrong direction in many European countries.
Thank you very much. Louisa, please.
Well, I think this is the question that I have not so much to say about, because I am here very much from the side of the policymaker, the legislator. So I do not have the rich practitioner experience that the other people around the table have. Having said that, I think strategic litigation in the broad sense has a very, very promising potential in terms of, first of all, testing limits to the legislation. I mean, we've spoken today about definition issues and what constitutes and doesn't constitute hate speech. And this is, I guess, also a moving target as society changes. But I think it's also incredibly important from the point of view of the victims and all the minorities affected by hate speech and hate crime, in the sense, as was mentioned previously on this panel as well, that in a society where we have parts of our citizens feeling like second-class citizens or not being taken into account in terms of the perception that the state has a duty to protect them. And there, I think, strategic litigation and showing convictions on hate speech offenses is very important. This is clearly something that we are not kind of dealing with directly, because I mean, we are not practicing the law. But from our point of view, and even more in societies where we see, I mean, challenges to the institutions, the role of civil society as the real kind of upholders of fundamental rights is incredibly important. So we're increasingly in our work focusing on enabling civil society. And of course, enabled civil society includes capacities also to engage, for instance, in strategic litigation. So I'll stop here. Thank you.
Thank you very much, and thank you for all your very valuable inputs. And thank you especially to András for mentioning the Hungarian Helsinki Committee as a as a strategic litigator, even in these faraway times. What I have to add is that this concrete lawsuit was in fact based on a concept elaborated by the then Minority Commissioner concerning the concept of harassment as an instrument to combat hate speech. So I think this is a very, very good example of cooperation, of successful cooperation of human rights NGOs and state actors that are ready to do and capable to do what they have to do. So now at this point, I would like to open the discussion to the audience. Please raise the questions that you have or say your comments.
Thank you. My name is Edik Uszkiewicz, and I would like to reflect to this panel and a previous one, because it was just mentioned that there's this Child Protection Act of Hungary, which is attacked before the Court of Justice. And we don't know right now the outcome, but I just would like to put this predicted decision into the Hungarian context, because we have to elaborate this one, I think, in this illiberal or populist regime or whatever we call it, because it's very promising that there's this huge coalition, which was mentioned by you, that 16 or 17 member states just joined against Hungary. But I'm pretty sure that if this decision will something against Hungary, then the political frame will be immediately that those homo Brüsselicus, although the court is not based in Brussels, but it's another issue, so those people there in Brussels are attacking us. The liberal forces are attacking us, the last savers of the Christian values, traditional values, and so on and so forth. So just back to this strategic litigation question, or this issue as well, what was raised, I would like to also ask your opinion that how is it possible to reach a kind of wider support from the society when, for example, the main source of the hate speech and this type of political narrative and this type of populist political communication is just the political agenda, and the main source of the hate speech is the government itself. So I think there are extremely strong forces against these kind of wider support from the society. And maybe it's rather a comment than a question, but obviously I'm curious on your opinion as well. Thank you.
Who would like to react on Eric's question and comment?
Yes, there is a risk. I think there is a risk with any kind of social transformation or change in society. There is always a risk of backlash. And I think that's something that, of course, has to be strategically considered. But I don't think it can paralyze anyone from not doing things. Yeah, I mean, if we start discussing issues that are not on the agenda or not, that don't have public support, there will be people who voice an opposition to our human rights cause. But if we don't raise it at all because we are afraid of the backlash and what kind of feedback we'll get, nothing will ever change. So I think it has to be taken into consideration. It has to be well thought through what strategies to use to counter that kind of backlash. But ultimately, unfortunately, that's how society changes. There is force and counterforce, and we only need, or the only thing we can have is hope that the force that is progressive, focused on human rights, will ultimately win. And unfortunately, there's not much other than hope that that will happen. And then we have to do, professionally, to our knowledge, to our everything that we can to make that happen. But I'm also very gloomy. I'm not just on the Hungarian developments, but if you look at political development throughout Europe, throughout the world, etc., unfortunately, the Hungarian government is not such an outlier anymore. So that's an issue that we need to focus on. And I think the fact that a lot of countries did join, that of course raised the profile of that case. It also shows that it's also the symbolic step that I was mentioning for victims, and I think was very important for the Hungarian LGBTQI community, that there is a sense that the European Union and many countries are saying this is enough, this cannot happen. So in that sense, there was the very strong message, even if legally speaking it will not change anything in the court procedure. It did have this symbolic impact very clearly, and I think those symbolic impacts are important. It's not just the legislation there. And to be honest, the European Court of Justice decisions are still much better implemented because of institutional reasons and the way that the the court decisions are implemented, they are much better implemented than the European Court of Human Rights decisions. So it's just much more likely to have an impact than a similar decision from the Strasbourg court.
Well, without reacting directly to the case you have raised, I can again only but echo what Tamás had said, that for example, as an ombudsperson, well, together with my colleagues, we do nothing else but hopeless. In many cases, we act and we do what we can, also in hopeless cases when we know that the outcome will not 100%, but we have to go further. We have to tell what we professionally think we have to. Well, and this is in line and coherent with all the understanding of non-discrimination and equality and human rights, what all the previous ombudspersons in Hungary have done. I mean, almost the original ones. Okay, so this is why I think it is not a strategic litigation what we are doing in the office, but it is a kind of strategic work in favor of different groups, minorities. So this is, for example, what we can do, and well, we try our best.
Thank you. Yeah, I mean, we just said that it is pretty, you know, heartbreaking to hear. But let me just say, if there was a pro-human rights climate, there would be no need for litigation at all. I mean, and that of course, that's never going to be the case. If men were angels, then we wouldn't need a government. And without this government, we could. Well, never mind. But on the other hand, I mean, I think that I think people should just be, and people are doing what they can. Just to refer to a classic, when again, when Nancy Fraser talks about equality, there's three dimensions: redistribution, representation, and recognition. If as far as symbolic justice is not a lot, recognition is by far not enough. If we're looking at the other two, obviously more important in the terms of existential consequences, but it's still not less than or more than nothing. And I think that's as much as we can do with. And I think it's, but also to be fair, I mean, it actually with the European Court of Human Rights judgments. I mean, I always, when I teach human rights and start talking about Strasbourg, I always say that I never stop being amazed by the efficiency of the whole system. Again, how counterintuitive it is. I mean, you would not expect it to be as effective to the degree that it even works. I mean, I always said even Russia, until Russia was, left the system, with the war in Ukraine. Even Russia made, efforts to appear as a country to be actually in line with. I mean, there are very few Hungarian European Court of Human Rights decisions, but the Hungarian government explicitly said that we're not going to do this. One of those was the Roma, school desegregation. But that was a very, difficult rhetoric or argument even for this government to make, right? I mean, you don't get to do that all the time. So yes, that's obviously not going to, bring salvation and at a fortnight. But I think it's I'm still, again, with contrary to all odds, this whole system still has effects that we should look at the glass as well, not half full, but at least a little bit of fluid is still down on the.
Thank you so much. Louisa, would you like to comment?
No, I mean, I think this is an ongoing case. We need to let it run its course. But for me, of course, it's very interesting to hear about how it is being discussed and reflected in your context. But I have nothing to add on it. Thank you.
Thank you. Are there any more questions? Yes, Peter.
Thank you. I was thinking about raising it or not, but perhaps it's worth raising it, that considering also the changing climate and what Gábor Polyák mentioned in the morning, that some of the regulations in Hungary are applied to protect, say, Christian majority and not the minorities. Would you consider on a European level some sort of application of the imminent danger test, which if we would conceptualize it in a way which would provide a broader scope, perhaps not only imminent danger of violence, but imminent danger of discrimination, and we could create a sort of a list. Could it be perhaps, in your view, something that could provide some more help for minorities, sort of real minorities, without running the risk that the regulation can be abused by sort of right-wing majorities? And I, just as a small footnote, I wouldn't confuse right-wing with conservative. It's really just a footnote. I think that we should really claim that those of us are conservative who takes freedom of speech seriously, and not those right-wing forces which also abuse freedom of speech as well.
Thank you. Who would like to comment on that?
I don't want to underestimate the importance of theoretical debates, but when it comes to hate speech legislation in Hungary being implemented, even the clear and present danger understanding of the law is not abided by. I mean, there are cases where hundreds of extremist groups, after hearing speeches of Roma criminality, we have to stop them, we have to do everything possible to stop them, then those people walking down the streets of Roma people, throwing stones at the Roma people, and then people being hurt, and then the Hungarian authorities finding there was no clear present danger of a violation of rights in that case by those delivering those speeches. Another case, demonstration against Budapest Pride, 100-meter between about 500 anti-gay protesters and the march itself. Let's go and beat up the gays, and then dozens of gays are beaten up. And then the Hungarian authorities say, well, it's not clear whether they were beaten up because those speeches were made. It's not the question of whether clear and present danger is a good enough strategy. Even that a very high threshold is just not kept by the Hungarian authorities.
Yes, thank you. True. I mean, not to disagree, with anything that has just been mentioned. Just to come back to something I briefly mentioned earlier is, and I think, when it comes to theoretical stuff, I think that the terminology is something that is worth a little bit dwelling on. Is when it comes and Tamás and I are in the sort of this working group on hate crimes, and there's a big debate, always a big debate, whether where do we draw the lines of hate crimes? Is it the narrowly defined hate crimes when there's stones thrown, etc., or also to include, of course, these are never in the pure shape of only speech, and then the clear and present or imminent danger test. So there's a big debate. Generally about the terminology. So the OSCE, whatever, long time published guidelines say, well, they say when you talk about hate crimes, it's not really hate crimes. We're not really interested in hate. What we're interested in is bias. So if, it's the simple definition, if the crime is committed because of racist, homophobic, whatever bias, then you get a more severe sentence. We don't need to, look into whether you hate or you don't hate, you just don't like, or, that's another story. So hate is to be actually not used and bias should be used. But the reason why I personally am okay using hate crimes is because hate, it's a good word, it's a strong word. We know what it's about. But when it actually comes to hate speech, then it's really hate that we're talking about. And then the question is, when does actually hate become something that should be sanctioned either criminally or in a civil way or another? So that's actually, I think, a very important question. And let me just say this: I always, it's a somewhat controversial issue, but I am really not happy with the way the terminology has gone in the past decades. And I think terminology, the use of words, is, if it's really off the line, then it will have some consequences. So phobia, when it comes to phobia, so homophobia, transphobia, phobia is something that we are afraid, and of course it's not being afraid, but being hateful or being biased and with an intention to discriminate. So that's really an unfortunate use of terms in this regard. And I think the other and again, it's not just being picky. I think the road that the term phobia has traveled. The next step had been is when how do we define transphobia? And again, the distinction between trans criticism, trans exclusionarism, transphobia, all of these are very different phenomena, very different cognitive processes, very different physical or verbal processes are behind it. So even that is I don't think that's actually helping, that we have this sort of this whole terminological scenes that we are using. I don't think that's actually helping a lot with this. And again, of course, this may sound very theoretical, and of course, practice is what we're interested in. Whether people whose rights have been violated, do they have access to remedies? Do they have access to justice? Is there justice in society? Is there justice in the legal system at all? But I think these are also connected. But I wouldn't want to hijack the discussion, but I can't stop mentioning this because this is bothersome.
Louisa, would you like to comment on this?
Yes, I have to defend our legal position. The framework decision goes beyond imminent threat. If we would have limited ourselves to the kind of immediate danger, then we would most likely only be able to cover cases of incitement to violence. So, there's where there is a imminent danger of violence, but under the EU law legal order, incitement to hatred is also falling within this criminal law concept. So for me, the concept of the imminent danger would be a limitation, actually, if anything, to the legal avenues of the victims.
Thank you very much. If I may add just one sentence to react on what András said about fear and phobia and hate. I think that fear and hate are very, very close relatives. So maybe this isn't such a bad formulation at all, because very often we hate what we fear from, what we don't know, what we have a very dark picture of, and that is when education, that was very often mentioned by all our panelists today, may come into place. So, and I think we just ran out of time. So thank you very much for all your very, very exciting thoughts. I learned a lot today, I have to say. And also thank you for the audience of being here with us and for actively following these discussions. So have a fruitful other part of the afternoon. Thank you.